Good morning. I just wanted to share my thoughts and comments after having listened to the argument before the court. I think it was very refreshing. I think the judges, while often the judges were confused, I think they were very confused by Abercrombie and Fitch's argument, which seemed to be that they thought their rule would lead to less stereotyping in the workplace, when in fact the facts of this case are that their employees that interviewed the applicant stereotyped her, assumed that she was Muslim and wearing the headscarf because she was Muslim, and for that reason did not hire her. She wasn't on notice of their look policy, as was brought out in rebuttal argument by the EEOC. They had stated the look policy in part, but it had not had any discussion about headscarves, and therefore she didn't know and was not on notice that she would need to request accommodation. And the record would show in many other cases they do make that accommodation. But here, because she was Muslim and because their assumption was that she was wearing a headscarf because she was Muslim, they did not hire her. And I think the justices pointed out in an example, there was an example given of a group interview, which is actually what Abercrombie and Fitch does. If there was a group of various people wearing garb for religious reasons, what would happen? And the government's answer and the EEOC's answer and the policy that has been in the other circuits and been good law for the last 20 years is that either if you stereotyping or not stereotyping, if you have knowledge that someone may need a religious accommodation, you can hire them, or you can have a conversation about what you, the employer, think is the issue, and have a discussion with them about whether or not that's something that they can comply with or need an accommodation. That's what the EEOC is asking for, and we think that is the right policy, and the test that's been in the, I believe it's the 3rd, the 9th, the 11th, the 10th circuits, not the 10th, but the other circuits, and the 10th circuit, because even though Abercrombie and Fitch had the knowledge that were assuming that this was for a religious reason, because they didn't know it from her, that was not sufficient to fall under Title VII. Title VII applies and should apply when the employer believes that someone is wearing something for a religious reason. And at that point, then, they are either hired because they are otherwise qualified, as the applicant was here, or there's a discussion. Abercrombie and Fitch decided to not hire her and not have a discussion, and that's the problem. So I was very encouraged by the argument. I think the exciting thing about this case is there's so many different civil rights organizations that have filed briefs and educated the court on the issue as presented. There's some dispute between the parties about some other legal issues, but on the issue that was presented and the issue before the court, I think the court has been fully educated, and I am hopeful for a decision reversing the decision of the 10th Circuit.
Federal law prohibits employers from discriminating on the basis of race for both employees and prospective applicants. Corporations like Abercrombie, in this case here today, attempt to undermine Title VII protections and circumvent the laws. They do this in this case by attempting to argue that they didn't have any knowledge that Miss Samantha Eloff, an Arab Muslim, was Muslim. However, she wore a hijab, and it's ridiculous to assert that that was not noticed enough. Now, in this case, the Supreme Court must reverse the decision of the 10th Circuit. It can have extreme, broad ramifications across the board amongst religions, including the Jewish faith and the Christian faith, because all of these religions wear articles of faith. A religious practice is exuded and shown through an article of faith, including a yarmulke, including a hijab, including a cross. And so we must understand that with the rise of EEOC complaints based upon religion, this case is extremely timely, and it's time for the Supreme Court to take a hard look at the acts of these employers and their attempts to circumvent and exude and portray their own stereotypical type of impression and bias on their customer base. They attempt to argue that providing an accommodation will have a burden on their company, that it will have inconsequential effects on their costs and ability to have a customer basis because they do little to no advertising. So that begs the question, is Abercrombie promoting an exclusivity of a group, exclusive of Arabs, exclusive of Muslims, exclusive of Hispanics, exclusive of blacks? And in this case, the Supreme Court must recognize and uphold and go with the EEOC. It is crucial to the protection of freedom of religion in this country and the protection of workers' rights in employment.